It's fantastic that we've got such a good uptake. Around 480 have registered, almost a sellout. I'm pleased to say that it's a truly multidisciplinary event with a whole range of individuals signed up, from the legal sector, including the judiciary, mediators, therapists and children's specialists, academics, the government and the charity sector, as well as others. The response is particularly impressive given the limited notice you've had, as the report, What About Me?, was published less than a week ago. I appreciate, however, that very few of us have any social engagements at the moment. But on a serious note, the response illustrates the interest and support for families following parental separation. The Family Solutions Group are particularly grateful for the support of the President and Mr. Justice Cobb, who were thrilled at joining us this evening. So, first, some housekeeping. Well, the event's going to be recorded, and details of how to obtain the recording will come up at the end after the webinar closes. On the panel, as well as the President and Mr. Justice Cobb, we have 4 members of the Family Solutions Group speaking. Helen Adam, our chair and a mediator, will first explain the background to the group. Dr. Jan Ewing, an academic from Exeter University Law School, will deal specifically with children, followed by Patrick Myers from the DWP's Reducing Parental Conflict Programme, who will address the important issue of the effect of parental conflict on children. Then, Helen will focus on parents, and I will cover the family professionals, particularly the legal community. There will then be time for some questions. Thank you to those who've already submitted some in advance, and feel free to use the Q&A function on Zoom to raise any more. Apologies if we don't get to the questions. We've already had quite a few and expect many more. So, enough from me for the time being, and over to Helen to explain the Family Solutions Group.
Thank you, Charlotte. We're incredibly grateful to Kingsley Napley for hosting this webinar on behalf of the Family Solutions Group. So the group was set up by Mr. Justice Cobb earlier this year as a subgroup to the Private Law Working Group in their review of the Child Arrangements Programme. The idea was to pull together a multidisciplinary group with practical experience of working with families outside of the court arena. We were asked to look at what can be done now to improve the experience of children and families before anyone turns to the court. Longer term reforms are being considered, but they're going to take time. And meanwhile, what are the quick wins? What can be done within existing legislation and rules to meet the needs of families who separate? Our group includes representatives from academia, women's aid, children's services and child contact centres, parenting services, including the Reducing Parental Conflict Programme run by the DWP, therapists, solicitors, mediators, plus a judge and representatives from Cafcass Cymru and MOJ. It has been a fantastic group, and for my part, richly rewarding to work on this project together and learn from each other. I'm only sorry they all can't be on the panel now. The theme that was woven throughout all our discussions was the need to restore the child to the centre in a system which largely operates for parents. Too many children suffer the consequences of a badly managed separation. Hence the title, What About Me? The pre-court space is a huge topic, and we divided into various subgroups to look at different areas. And so the report is essentially a collection of contributions from each group. It is not an academic paper. It's certainly far from perfect, but it is our offering for what we believe children and parents need. It is yet to be reviewed by the Private Law Working Group. We hope it will stimulate new thinking and creative approaches for all family practitioners. I'm now going to hand over to Sir Andrew McFarlane, the President of the Family Division. He published today the latest view from the President's Chambers, and having had a quick glimpse, they're only too aware of the huge amount you have on your plate. So we are extremely grateful that you and Mr. Justice Cobb have given your time to be with us today. Thank you.
Thank you, Helen. I'm very pleased to be here. I think the publication of this report by the Family Solutions Group is the most exciting thing that's happened in family law for a very, very long time. And yes, I have used the words exciting and law in one sentence. on that occasion. It is exciting. Those of us working in the system long for a better way of helping children, of helping parents resolve what are, in effect, relationship difficulties when they break up. There are sadly many children, many parents who need protection from harm, and they rightly turn to the court and hopefully get protection and priority in our system there. But very many don't have those sad difficulties. They've just become stuck in sorting out the difficulties that they have as adult parents in making arrangements for their children. And now it's thought, although the stats are not very robust, about 40% of separating couples turn to court. Well, that can't be right. It can't be right that lawyers and judges, or even people without lawyers in front of judges and magistrates, need a system like that to solve relationship problems and make arrangements for their children. So it's exciting because this is focused work on that very topic, which is one that's very close to my heart. It's also exciting, I think, to hear Helen describe how the work grew out of the private law working group, which was a sleeves rolled up, nuts and bolts wide group looking at processes within the system and what we can do. And as I understand it, this was a group of volunteers, or semi-volunteers at least, who wanted to get round the table and discuss the bigger issues. And it's good that the private law working group gave them the space, as it were, to do that. And now, with the publication of the report, the voice to be heard with what they have to say. So it's exciting that that's developed out of what was a wide system, wide private law working group to look at the COVID crisis and indeed the pre-COVID difficulties we had with the volume of work. But the real excitement comes from the substance of what they have to say, and I should have said how grateful I am to each of them for the hard work they've put in. But the excitement is in the substance, and I hope many of you have had the chance already to read the report. It's a good read, and really it's a bit of a page turner for those of us who've been in this field for a long time. It follows on awfully 30 years ago from the Children Act. It has to go back to that to remind us what the Children Act was about. I spoke to a government minister last week who still used the word custody for arrangements for children. We still have to think back to the very radical change that the Children Act sought to bring about, and we still have to be delivering that change and those messages. It goes back to the work that Nicholas Wall did and his group on making contact work. I recall a meeting such as this with live people in one room about this number at the Queen Elizabeth Conference Centre one Saturday morning on the day when the anti-Iraq invasion march was going on outside. It goes back that far, making contact work. It goes back to the Family Justice Review. But we've never got it right in the sense of having the major change that I think we all feel should be taking place. And all of those groups that I've mentioned, and this one, talk about a need for a change of language, a need for public education. And what's good about this report is that it draws together, it gives it a framework, so that the word holistic, very happily for me, is used to show that everything needs to be joined up. People need to be in communication with each other, with the services they're providing, and working together with a common understanding. All of these messages are there, but they haven't worked thus far because in the end, the people trying to roll them out have been the courts, the lawyers, CAFCAS, academics, people in the family justice field. And in the end, we only really have access to move the deck chairs around in our bit of the business, whereas we really need something that's going to connect with parents before they even think of coming to court. We in the court only know they exist when they've issued an application and walked through the court door. And often it's too late then. They've got a mindset that they want a resolution based upon court process, judges and the rest. And it's very difficult then to manage their expectations. to divert them somewhere else. So this is really important because it draws in detail what should be on the apron of the court, as it were, before people even get anywhere near the court building, and hopefully within what's provided there, find a way, if they can't do it themselves, of resolving their dispute. I'm also excited because the time feels to me ripe for this to be looked at by society in general, by policymakers, by politicians. The divorce reform bill is coming through. The volume of work in the family justice system continues to rise and rise and rise in terms of private law. So there's still a feeling that something needs to be done. And so I earnestly hope that this will be taken up by all of you attending tonight, but also the wider public. We need to talk about this. We need to get out the message that it's not a very smart thing to do to end up in the family court if you don't need protection from abuse and harm, and all you have, it's important, but all you have is a relationship difficulty. There are better ways of solving it, and we need to do everything we can to make sure that society and the system signpost you to support services for that, rather than having the only game in town being issuing of an application to the family court. So excited I am, yes, and so should all of you be. And thank you very much for including me this evening.
The first report.
I should have handed over to Stephen Cobb.
Here I am. The first report of the Private Law Working Group, which was published in 2019, made some tentative recommendations about supporting separating families, in particular the children of those families, outside of the court system. We proposed, if you remember, the formation of alliance of services supporting separating families alliances, and these, in their infant state, are being trialled in a few areas. They look to have a promising future, but we plainly needed, we felt in the group, to have a longer, deeper and more expert look at the experience of separating families, assessing the information and opportunities available to them, and seeing what more could be done to support them, and in particular the children of separating families. The composition of the Private Law Working Group, which was mainly family justice professionals, was not well equipped to undertake this particular task. Hence our invitation to Helen Adam, a member of the Private Law Working Group, to form and chair this group. The work of the group and the report, I'm sure you'll all agree, more than amply fulfills the task that they were set, and I'm extremely grateful to them. I will let them speak to the report and its content, but time doesn't stand still in the field of family justice. Many complain that the wheels turn slowly, but at present there is an energy to drive forward reform, and I propose just very briefly, in a minute or two, just to explain to you what's happened in the last few months. We completed our work on the Private Law Working Group in March. As you know, the Harm Panel, the Ministry of Justice Harm Panel, published its report in June. In September, the Family Justice Reform Implementation Group reformed to look at how we could drive forward reforms in this field. And at that time, I was asked to chair a very small private law implementation group, pulling together the recommendations of our report, the Private Law Working Group report, the Harm Panel report, and with a sneak preview that I had of the Family Solutions Group report, the recommendations of this report too. And within the last few weeks, this small group has pulled together a report for the Family Justice Board, a board which, as you know, is chaired by ministers, which strongly advocates the need for systemic change in the way we deal with, manage and support our separating families. The reports that we drew on have many themes in common. The most striking is that a significant reform of private law processes is greatly needed, long overdue, and now critical. What the coronavirus COVID-19 pandemic has shown us is that the family justice system has itself many, many flaws, and the volume of work that has been generated during this period has served to place the system under unprecedented strain. The report that we've prepared for the Family Justice Board, which was considered by the board last week, recommends the design of pilots which will trial new ways of managing separation for families. In our designs, we will hope to walk the path of separated families from the point of separation, so that we capture that which you have advised, the Family Solutions Group have advised, and that we consider to be necessary to ensure that where safe to do so, the issues of families that are separating can be resolved satisfactorily and in a cooperative way outside of the court system, and that children are involved as appropriate in the arrangements that are being made for them. We're very keen to ensure that we strive to improve the outcomes and life chances for children and young people affected by family separation. We've placed before ministers the need for them to support and enhance a change in the culture of issue resolution for separating families inside and outside of the court. We recognise that a change in culture will not happen overnight, and it's unlikely to happen at all without government-supported programme of public education to advance these objectives. Culture change will need, as you have emphasised, the Family Solutions Group in this report, to bring with it a new lexicon to complement other reform strategies. As you have pointed out in your report, and as Andrew has earlier mentioned, this programme of reform comes as a of the Divorce, Dissolution and Separation Act 2020 introduces no-fault divorce. We propose to the Family Justice Board that urgent thought be given now to achieving better coordination of ministerial responsibility for separating families across government, with effective coordination across England and Wales. We consider that there is a considerable benefit to be gained in a single department or ministerial role with an overarching responsibility for family breakdown and separating families. We, I think it may be clear from the way I put it, are very excited by this project and are grateful indeed for the infectious inspiration and enthusiasm which the Family Solutions Group has brought to our work. I finish by simply offering you my profound thanks for all that you did to help us. Jan.
Thank you so much for that, and thank you everybody for joining us this evening. I'm Dr. Jan Ewing from the University of Exeter, and with Judith Timms and Debbie Singleton from the National Youth Advocacy Service and Elizabeth Cobb from the National Association of Child Contact Centres, my role on the Family Solutions Group has been to look at services for young people. So in the short time I have available to me today, I wanted to suggest to you why it's critical that we reframe our approach and put the needs and voices of young people centre stage. And also I want to consider what the priorities are to effect this systemic change that we seek. I think the why part is the easier part to answer, because put simply, the 280,000 young people whose parents separate every year, at least 20% of whom will have experienced domestic violence in their home lives, deserve nothing less. For too long, we believe, ownership of private law policy has been fragmented across too many government departments, when an overarching policy lead, as we've just heard, is vital if the needs of those young people are to be adequately met. For too long, young people's voices have been drowned out in the adult-focused decision-making process when their parents separate. For too long, the court has been looked to as the third parent and asked to micromanage decisions that parents should and could, with support where needed, be making themselves. The court is a blunt instrument for dealing with many parenting disputes in the absence of safety issues. and it's also likely to exacerbate conflict. And the research evidence is clear. Parental conflict is psychologically damaging to children, and it impairs their relationships with both parents well into adulthood. Young parents deserve better than this. Not only do they deserve it, but they have the right under Article 12 of the United Nations Convention on the Rights of the Child to express their views freely in matters affecting them, with their views given due weight in accordance with their age and maturity. And this right extends to decisions made outside of courts, such as in mediation. Yet we know that in practice, this right is so often denied to children. Thirdly, hearing from children improves not only their experiences of the processes, but also the outcomes. Young people that we've spoken to in our research tell us that feeling listened to and respected in the decision-making process has been cathartic. Research shows us that being involved in decisions about contact is associated with a positive experience of contact, arrangements made are longer lasting, father-child relationships are better, and parenting is more cooperative. And so involving young people in those decisions not only makes it a more positive experience for them, but improves their outcomes longer term. And the changes that we're seeking make safety of the child a priority. But in the absence of safety issues, we're looking to provide holistic support for parents and young people so that they can be supported to make arrangements without engaging the court. So what needs to change then? Well, we believe that the change we seek requires the establishment of a framework of universal, non-stigmatizing, well-signposted services for young people, providing information, consultation, and for the minority who may need it, representation, formulated around their Article 12 rights. Firstly, the 280,000 young people whose parents separate every year should have ready access to marked information and clear signposting to good quality support, offline and online. This would require a coordinated strategy to ensure that those resources are made available to young people when their parents apply for a divorce, but also being, just a little more creative in how we do that. So perhaps in schools as part of PSHE education, or other touch points for young people such as GP surgeries, that sort of place. Because research tells us that failure to provide information for young people at this sensitive time compounds their sense of confusion and uncertainty. Provision of information and signposting to support could be made relatively cheaply and easily at this stage, and it will empower young people and help to alleviate distress at this difficult time for them. Next, we think that there should be a presumption that all children and young people aged 10 and above are offered the opportunity to have their voices heard directly in all processes for resolving matters between their parents, whether that be mediation, solicitor negotiations, collaborative law, or arbitration. All processes outside of the court should provide a real opportunity for young people to be heard. And to embed this as the norm will require an urgent review of funding of processes such as child inclusive mediation, but also a change so that there's a requirement to maintain annual statistics around the offer that's being made to the child to incorporate their views, so that we have a real record, a record of what that child has been offered. Finally, we think that the Section 10 Children Act leave requirements should be reviewed and relaxed to enable competent children who are in need or at risk to find a route back to court of their own volition if needed. As Lucinda Ferguson from the University of Oxford has argued, it does children a disservice to give them a right to be heard in theory unless in practice that right is exercisable and leads to better outcomes as assessed by the child. Young people deserve nothing less than a fundamental culture change so that that right to be heard is exercisable in practice and no longer just in theory. Thank you. I'm going to hand over now to Patrick Myers from the Department for Work and Pensions. Thank you.
Good evening, and thank you very much for the opportunity to talk to you this evening. I'm glad to see so many people have taken the time out to arrive at this important webinar. I want to just talk a little bit about conflict. And conflict in relationships is expressed through many different behaviours which can impact on families' lives. When conflict is between parents, it can have a negative effect on their children's current experiences, but the reach of this can last a lifetime. Disagreements in relationships are normal and not problematic when both people feel able to handle and resolve. But when parents are entrenched in conflict that is frequent, intense, and poorly resolved, it is likely to have a negative impact on their children. A comprehensive report by Professor Gordon Harold and others in 2016 demonstrated that there was scientific evidence that the role of the couple relationship is a significant factor that affects children's psychological outcomes and long-term development. This evidence now is well established and reported widely. It highlighted that the quality of the interparental or couple relationship, whether parents are living together or separated or separating, does play a significant role in affecting children's long-term emotional health and well-being, behavioural and academic outcomes. And it also states, which is an important finding from this, that parenting programs alone will not help in these circumstances because it's often the parental conflict that is driving the parenting practices. Separating parents must be given the necessary information about the impact of the conflict on their children. This is because we know from the Millennium Cohort study by Fitzsimmons and Viladsen that children who experience a separation, whether married or cohabiting, are 16% more likely to experience emotional problems and 8% are more likely to experience conduct disorders. We also know that separation after the age of 7 results in an increase in internalizing behaviors for both boys and girls and externalizing problems for boys alone. If parents are separating, we need to find ways to help them to make it happen in the best interests of their children. We need to mobilize the evidence so that children's lives are made better now in order to avoid some of the longer term consequences that have been articulated so well by Gordon Harold and the Early Intervention Foundation. And we need to emphasize it is the quality of the parental relationship that matters, and that in the interest of children during separation should be center stage. We know that interparental conflict harms children, and the intergenerational transmission that often is associated with this model of parenting behaviors continues the cycle, and we know that's not healthy. I'm going to end with words that are not mine, but ones which I think encapsulate what all this means for children and separating families. Brian Cantwell from the Family Conflict Centre in Hexham puts it like this. A final point I would add to the key emotional agenda is that of the child. In my view, a child's fundamental right is to witness their separating parents behaving collaboratively and on the basis of a shared definition of their best interest. When parents are in unresolved emotional conflict, they are unable to offer their child this reassuring consistency. Their different narratives may leave the child with conflicting life stories. This can lead to serious consequences for the child in terms of a confused self-image and the resultant lack of security, in contrast to the child with a consistent sense of their history and themselves as a loved child. The adage that it is not the fact of parental divorce that disturbs children, but the way that divorce is handled remains true. I think I agree with that. Thank you. I'm now going to hand on to Helen, I think.
Me. I need to unmute. Thank you so much, Patrick. So let's now step into the shoes of parents and consider this from their perspective. We've heard that parental conflict is harmful to children. So what do we know about parents? Well, first, Separation is a turbulent time, and it will raise a host of emotions ranging from heartbreak to hatred. The second thing we know about parents is that they love their children. Most want to be good parents and they want the best for their child. And so inevitably there's a tension. And as we know, the emotional landscape of parents often determine the arrangements for the child without any real objective view of what's best for the child, either now, next week, next year, or even for the decades to come. I was in a phone-in on a Kent radio station not that long ago, and a lady rang in and said, my parents separated badly when I was a child, and now my children are growing up knowing Granny and Grandpa hate each other. It continues for decades when it's managed badly. Our private law system exists to protect those who are vulnerable, but actually offers a platform for difficult emotions to be played out as parents go legal in the hurly-burly of upset after separation. And this isn't just the 40% who turn to court. Too many childhoods are dominated by conflict when parents separate on bad terms. The thing is, we can't tell parents to be reasonable and expect them to get on with each other. Saying don't be angry doesn't stop one feeling angry. Parents need an incentive to understand why this is important, and they also need practical support. Otherwise, it's not going to happen. So these are our suggestions for parents. First, as the President has already said, and as he says has been asked for over many, many years by many before me, we need a major public education campaign. And this is not aimed at just those that want to turn to court. This is a major public education campaign about parenting when parents separate. It feels a huge ask to shift societal attitudes, but it is both possible and necessary. If you think what Joe Wicks has done for the health of the nation in COVID, we need another Joe Wicks or someone equivalent for this campaign. It has to catch the hearts and minds of the people. There need to be some clear messages understood. Parental conflict harms children. Custody doesn't exist anymore. I won't allow the term in my mediation room. I show them my pen. I say, I own this pen, I have custody of it, but I don't own my children, and we won't talk about children in a language of custody. Parents have responsibility rather than rights, and in the absence of safety issues, both parents have a responsibility to promote the child's relationship with the other parent. Yes, time with a child is important, but the way we relate to the other parent is also important. And children fundamentally need parents who don't live out their hatred for each other over the years ahead. These are very hard messages, but they need to be widely understood by society at large. We think the timing of the new divorce legislation is an ideal moment to catch the wave, and I hope that government will respond to this proposal. Next, and linked to the education campaign, there needs to be clear, accessible information for parents, accessible from the moment they separate, not just when they're thinking of turning to court. There needs to be an authoritative website and also information available from all touch points, schools, GPs, health visitors, citizens advice bureaus, libraries, wherever. The same clear information. At the moment, there's a plethora of websites and information, and it is confusing and overwhelming. Our next recommendation is absolutely vital, especially following on from the Risk of Harm panel report that came out in the summer. Families need to be screened at a really early stage to assess their needs. The family court exists for those who are vulnerable and for those who are victims of abuse, and they need to be directed straight into the system without delay and before issues escalate and more people are at risk. So that early screening we think is really important. And those with safety issues should be directed onto what we call the safety pathway. Other families need support along what we call the cooperative parenting pathway. And our remaining recommendations are all aimed at parents along that pathway. So what do they need? Well, fundamentally, they need a holistic approach. They need legal information to help them know where they stand. They need therapeutic support to acknowledge and address their feelings. And they also need a safe process for resolving issues with the other parent. And for many, that process may be mediation. It works well for many. It doesn't have to be mediation, but they need a safe process to address issues with the other parent. I like to think of it as a three-legged stool of legal information, of therapeutic support, and a process for resolving issues together. We've made a distinction in the report between legal advice and legal information, and I just want to spend a moment because there's a real difference here in the direction that parents take at the moment they head off to get that legal information. If they see separate solicitors for advice, it can set up a disconnected process where parents are advised against each other, with the risk that that may set them further apart. Whereas by contrast, if they obtain legal information, it can be given to both by the same person on a mutual basis. Now, of course, in cases where a genuine legal issue arises, they should be diverted to obtain proper legal advice. But here we're only talking about private law cases for children. We're not talking about finance cases. And for those families who drift into court and need legal information because the public is not aware of what the law says, legal information is a good starting point. Our final recommendation is for parents to have easy access to a parenting programme. There are loads out there, some really, really good ones out there, but they are disparate with no oversight or coordination. We would love to see them come together to form a national body of parenting programmes so that any parent who separates can easily access quality information about parenting from a programme accessible to them. Overarching these recommendations for parents, we encourage at all times an approach which is mindful of the language we use and which supports parents to work together where safe to do so. And alongside that, we need to keep parents focused on the long-term goal to give their best to the child. The professionals who gather round the separating family at this vulnerable time have a critical role to play in containing the fallout and preventing issues from escalating. We all need to work together, just as we ask parents to work together, just as we ask government departments to have joined up thinking. We, the family professionals, also need to join together and collaborate as we gather around the separating family. So I'm going to hand over now to Charlotte to talk about our role as family professionals.
Thank you, Helen. So I'm going to highlight some of the recommendations that we've made in relation to the legal profession. Like the rest of the report, we've concentrated on the pre-court space right from the moment that clients contact us. We've focused on solicitors, and I include legal executives in this, as they are more usually approached at the outset. But many of our recommendations are equally relevant to others in the legal profession, including the bar and the judiciary. Like other members of the Family Solutions Group, I took part in my personal capacity rather than on behalf of Resolution of the Law Society. And our recommendations are based on my and others' experience as solicitors, which coincided for me with my 25th anniversary as a family lawyer. We were also fortunate to have on the committee His Honour Judge Martin Dancy, who shared his valuable experiences as designated family judge for Dorset. And while I'm an accredited mediator and collaborative lawyer, the bulk of my and my team's practice remains as a solicitor, acting for one spouse or parent, and like many of you, I regularly act for clients in litigation in both private children and financial disputes. I appreciate that it's a long report with many wide-ranging recommendations, but for the legal practitioners, I actively encourage you all, including those representatives from the Law Society and Resolution, to respond to the recommendations, agree, disagree, but engage in the debate far beyond this evening. Now, Resolution has had a hugely positive influence in the good practice of family law, and I'm acutely aware that much of what we have recommended has previously been said by Resolution and others, such as firms like Family Law and Partnership, who have long advocated a multidisciplinary approach and specialist non-legal training for family practitioners, another key recommendation. So why the recommendations? Well, first, as solicitors, in private law, we only advise one parent, not the children, so that from the outset, the position is potentially adversarial. We underestimate the power that we have as lawyers to influence the path of the client who is hugely vulnerable following relationship breakdown. Whatever path the client takes can influence the whole family's future, particularly the children's. Family breakdown, as we've already heard, is still seen as a purely legal issue, even though many parental disagreements about children are not legal disputes. And so it is culturally embedded in our society that solicitors are the first or only port of call for clients whose relationship is breaking down. And for those clients who cannot afford to instruct lawyers, the default is often to issue an application to the court. I should reiterate that the court remains the appropriate forum for many families, including those where there's been domestic abuse or child protection issues. But as has been said by many before, the court should not be thought of as the only or indeed always the first option. Of course, a good family solicitor will refer clients to other appropriate professionals, particularly important in the early stages where the client is coming to terms with the relationship breakdown. But many family lawyers have had none or limited training on important issues such as the effects of parental conflict on children, the screening and impact of domestic abuse, the psychological effects on parents of relationship breakdown, including mental health and addiction issues, and, importantly, the non-court options available to parents to resolve family disputes, or issues, I should say. This lack of training can affect whether and which professionals are recommended or what steps the solicitor advises the client to take. Unless the solicitor has had specific training on these areas, it's down to the quality of the lawyer or firm whether they refer clients out to other professionals, such as child therapists or counsellors, or whether they explain to clients all the different options that they can take. As we all know, there are some lawyers who actively discourage resolution membership or always advise against non-court options. As family lawyers, we underestimate the effects of contentious children or indeed financial proceedings on the family, which has an inevitable impact on the parents' parenting relationship with ongoing conflict for children. Good practice by all family professionals will look beyond the particular issue in question and consider how the different processes will affect the parental relationship in the future. So, one of our main recommendations is that all those practicing family law have mandatory core training on the psychological or non-legal aspects which I've just highlighted. Unless such training is mandatory, it will always be the same practitioners who choose to do the training, much of which is already out there, and which helps us as practitioners to deal with our cases and indeed our own well-beings. Another of our key recommendations is for solicitors to have a broader understanding of the options or processes available and to inform clients of these. I've had conversations with many lawyers who've told me that they support mediation to deal with a children disagreement, but they would never recommend them to use mediation to agree a financial settlement. They raise the power imbalances in relation to money. I understand this. Financial abuse and coercive control is, of course, an important element of domestic abuse. But as the report highlights, we should encourage processes to support parents to work things out together rather than setting them against each other. There are lots of creative and multidisciplinary models involving mediators, solicitors, barristers, and others which support parents to reach an outcome together. And if an adjudication is required, then more people should consider arbitration, which will hopefully be boosted by the recent Court of Appeal case of Haley. Now, the report also addresses accountability. Many family solicitors are members of Resolution, which has at its core the Code of Practice, which aims to reduce conflict and encourage families to put the best interests of any children first. But I know from my days on the National Committee of Resolution that it can be difficult to enforce the code, and there are also many family solicitors who are not Resolution members. Many forget that the Resolution Code is endorsed within the Law Society's Family Law Protocol, which was most recently updated in 2015. so it applies to all family practitioners and emphasises the need to achieve resolution by non-court routes. But in our experience, the protocol is rarely raised these days, and our recommendations include greater accountability of solicitors, including a new and expanded protocol which must be available online and free, and encouragement to the judiciary to give it weight. And for proceedings that have already been issued, there should be a stronger regard for Part 3 of the Family Procedure Rules to encourage and facilitate the use of non-court dispute resolution. By way of reminder, Rule 3.31 states that the court must consider at every stage in proceedings whether non-court dispute resolution is appropriate. But to have teeth, the judiciary have to enforce it, and the group support the Surrey initiative of one of our members, Karen Barham. Annex 10 to the report sets out the details of the initiative. Finally, one of the main threads in the report is an improvement in interdisciplinary practice. We recommend a greater understanding by the legal profession of the different services available to clients to support them, including parenting programs. Many family lawyers are crying out for names of good professionals, such as child therapists, to refer their clients to, and we recommend a move towards local networks of family professionals to promote an integrated approach to problem-solving issues between parents, with legal services playing a part. While this, of course, can be harder in larger cities such as London, even on an informal level, it is essential. I can comfortably say that some of my most grateful clients have been thankful, not for my legal advice, but for putting them in contact with other professionals such as good child therapists or psychologists. Now, I'm aware that professionals reading the report will inevitably be looking at it through the lens of their own profession and how any recommendations might affect them. While that's understandable, I just hope that the different professional organisations, whomever they represent, work together collaboratively, discuss issues, and, using the language of the report, work cooperatively as we hope and expect our clients will, as we strive to improve the family's experience following relationship breakdown. Thank you. So I'm looking at the time. We have left some time for questions. We've had, as I said earlier, we've had a number before, but we've also had quite a few during the session. So I think if I can kick off with one question we had in advance. What is the single most important step to get these disputes out of court? Patrick, could you answer that?
Yeah, I can answer that. I think it's the appropriate people out of court, or families out of court, because we've already highlighted there are some people, some families or some parents that actually need the protection of the court for a variety of reasons. But we also have heard today about the lack of national coordination around the work for separating families, and I endorse some thinking around what that might look like around separating families. And we've also talked about collaboration at the local level, and we've already mentioned the supporting separating families alliances that are embryonic at the moment, but I think have some ability to actually coordinate the range of services that might be available in a local area that can support parents to do the type of things that I alluded to about placing their child at the centre and thinking around alternatives to court. But also that we need to make sure that if in those alliances that separating families have access to the information about those alternatives and are actively supported where appropriate, and I emphasise that, where appropriate, where there's no risk to one parent or their child, that they can find other routes to settle their disputes in a, and I'm bound to say this, in an environment where conflict is not the necessary context in which the negotiations are going on. That's my view.
Thank you, Patrick. Does anybody want to add anything or no? We've had one question which I will read from the Q&As. Reference is rightly made to previous reports that span many years, including that of Mr. Justice Wall, the recommendations of which sadly have not been properly implemented. Is there any indication as to who in a position of real power will be approached to make more tangible progress this time? Well, I think it should be the President that asks that, if you're happy.
No, well, I'm very pleased that the way you put it, Charlotte, acknowledges that I'm not in a position of any real power. Unfortunately, as the report shows, responsibility for this area of government policy is split between three departments: Patrick's department, Department of Work and Pension. There's the Children's Minister within the Department for Education, and there's the Ministry of Justice. And so there's a need for really the message to be presented to those three departments, and for a cross-governmental approach to be taken. Someone needs to take the lead. At the moment, we're fortunate that the Lord Chancellor has some direct knowledge of this work. He was a practicing barrister. As it happens, my regular meeting with him, which I have every 2 or 3 months, fell last week. I know he's had the report already. We discussed it already. And so there's a need to move forward. He has, or publicly, he would, I think, be happy to be stated as separately having an agenda to look to diverting people away from court. And so that leads me with more confidence to feel that the time is ripe now to raise the question with the government across these departments. And it's right that it should be raised across the departments, because the children that we're talking about come to us in a family law context, but if they're really messed up by what goes on in the fallout of their parents' relationship, they may well pop up with behavioural disputes, they may well pop up on the edges or even the centre of crime, they may well have health consequences of what goes on, they may well not end up being the sound adult citizens that they would, we hope, otherwise have been. So there is a cross-government interest in this, which goes far wider than simply coping with the case on the day at the court and dealing with it that way. So the question is right, that unless we raise this profile at a high level with those who do have the power to make a difference, then this report may have the same lack of success of previous reports. But I do feel that the time is ripe at the moment to get that at least moving forward.
Thank you. Helen, I was going to come to you actually, because it's quite connected to the earlier question we had in advance, which was who's going to ensure that the report's findings are implemented. So I don't know if you want to comment on that.
I was just going to add to that, which is that we can all sit back and wait for somebody else to take the lead on this. But I actually think that it's down to all of us. I think if we care about the children in the families that we come across, then all of us need to buy into a new language. And we called the report Reframing Support. We need to reframe cultural attitudes. It's very interesting in the news, been lots of news about the overloaded courts. Not one news item have I heard refer to what that means for a child. Not one. Talked about the frustrated parents and the huge pressures on the family court. But I haven't heard the reference to the child. And in all of this, we need to be reframing. We need to be turning it round always. How does that leave it for the child? What's the child's experience here? And if that is woven through all our professional practices, all our social contacts, and whoever we meet, then we can do our bit.
Yeah, good. I'm looking at the time. I think sorry, anyone else want to add anything? Time for another couple of questions. I think one that perhaps Jan, if you don't mind dealing with, I'll say it first and you can decide. There's a question about the use of court for those families that aren't emotionally ready to negotiate, but might be told that they shouldn't use the court as it's not a domestic abuse concern. What would you think about that?
So certainly in the research that we did in mapping, a lot of the reasons that processes like mediation broke down was because people weren't emotionally ready. And then of course, if that out of court process breaks down, the only option they really then have is to go to court. So I think it's all about the way that we reframe things. We've got to provide an alternative for people. So you know, we've got to make sure that the person who isn't yet emotionally ready gets the support that they need, and perhaps that we need to be educating both parents that actually, you could press ahead. If you're the person who is emotionally ready, you could press ahead with a court application, but ultimately that may not be in your child's best interest. But if you were to pause, put something temporary in place, and we work to get the other person to a place where they are emotionally ready, sometimes by the passage of time, but sometimes with some therapeutic input, then you get someone to a place where actually they can sit down in a non-court process such as mediation, or many of them should be able to, and resolve matters that way. And then of course, if that's not possible, then someone may need to make an application to court. But I think there's much more we can be doing to support people. It's about giving people alternatives, isn't it? If we don't give them a viable alternative, if we don't give them a holistic approach, then they will go to court. So it's how do we do it better so that they can make those decisions without having to go to court.
Thank you, Jan. I think there's one question which I think a lot of us would like to answer. So I think if we can go to that. Looking forward, say 3 years, what would success of this project and its recommendations look like for families? I don't know who'd like to kick off, but I imagine a lot of us would like to comment on that.
I start first. And I'm bound to say this from the area which I work in, but actually we need to make sure that the messages around interparental conflict are within the ether, if you like, very much alongside the report. It's about our responsibility to making sure those key messages are out there. And the impact of separation or and court-based separation does have an impact on children. I've indicated to you in my chat just now about the impact that it has on children, and we need to make sure the parents understand that. And so there's almost, in my mind, a public health message, if I can borrow Martin Dancy's ideas around that, but we need to actually make sure that the information that we have about the impact of this actually resonates throughout society as a whole. Parental conflict harms children.
Jan, do you want to?
I think sort of, yeah, allied to that, I think that the measure of success will be the stories of the young people whose parents have separated. So I think that if we've provided young people with a meaningful route to have their voices heard, and if the experience for those young people is so much more positive than the experiences of people to date, so that we don't have people like the lady on Helen's phone-in saying, actually, this is the second generation of fallout within our family because of a very acrimonious divorce. So I think if we've got young people who are saying to us, actually, I had a supportive process, and yes, it was hard, and yes, I was upset, but actually my parents talk to each other, they go to my parents' evening, and down the line they come to my wedding, then I think that that is a measure of success.
Shall I go first and then perhaps leave Helen to say the last few words? I think for me, I think the training, making sure that people expect that they need to do the training and they realise the benefit of it, to look at things holistically, as we've heard a lot about tonight, and for the professionals to work well together, whatever path they're from, and to have a good body of non-legal professionals that they know who they can refer to. So it's no longer the norm to go to court. And actually already, I'm having looked at the chat, just to finish from me, it's very heartening we've already heard from the Law Society, the Law Society Family Law Committee met today, and they're already working on the revised 5th edition of the protocol, which is, and they support what the report is saying, which is fantastic. And we've also, the FMC, FMSB also welcome and endorse the report. So what would be fantastic is for the different organisations to work together to really improve families' experience. Helen, I'll leave you to say the last few words, unless, of course, the President and Mr. Justice Cobb would like to say something.
I suppose I would hope that in 3 years' time, when parents separate, there is just a sort of cultural understanding that it doesn't have to be a fight. It's not an adversarial process, that they're going to go on being parents together for many years. I'd like there to be a clear understanding of those two pathways so that people who are at risk are genuinely screened early on and get the support they need, and that everybody else is helped holistically with therapeutic support, parenting programs, good professional advice to move on to the long-term goal of cooperative parenting. And I think that, you know, for parents not to be afraid of the fight and to understand the need for cooperation, that will be a great outcome. I was working with a couple in mediation this afternoon. They came in July. Life at home had been terrible. They'd been arguing. It was all very conflicted. She wanted to end the marriage. They have 3 children, and he was at a terrible state. And it was very, very tense, and he was on the edge of a breakdown. Anyhow, they've been going to counselling just to cope with the emotional side. I've been seeing them in mediation along, and they said to me today that they're now being kinder to each other. And they said from where we were in the summer, there's so much less acrimony. From where we are now to where we were, we couldn't really ask for much more. So they're on their way. They haven't yet done the finances, but they're on their way. And I think if we can stand alongside families and help them along their way during this very difficult transition of separation, then that would be a good outcome in 3 years' time. Thank you so much. Mr. President and Mr. Stephen Cobb, do you want to say anything else in conclusion?
Well, I'd just like to say, I think both I and Stephen used the words exciting and infectious in what we said at the beginning. And I hope every one of the nearly 400 people who've been observing this webinar have caught that, have really understood that we are at a moment, and this is our stuff, and it's a chance to move matters forward. And if we were in, it would be a stadium, wouldn't it, with nearly 400 of you, but if we were in a room, I would like to eyeball each of you, and it's down to each of you, it's down to each of us to talk about this report, not just amongst ourselves, but if you know your MP, talk to the MP about it. If you know your GP or anybody out there in the system, share the infectious enthusiasm that I think we all have for this. And it's by lighting a fire underneath it and letting it take off that I think we might get somewhere. But I'm extremely grateful to everybody who's been involved for getting it this far. And it's now down to a lot more of us to take it on. So thank you for an excellent webinar.
Thank you.
And thank you so much. As I said at the beginning, it's I'm sure the 400 or 500 has a lot to do with you, Andrew, and Stephen. So thank you very much. And thank you everybody for listening. And thank you, as Helen said, we couldn't have all the group on the seminar tonight, but it was for me, it was an honor to be on the group, to work with such fantastic professionals. And yes, let's all carry on talking about it. So thank you all, and the webinar will now close, and I think a couple of slides are going to come up at the end. Thank you.